All right, it is a pleasure to call this meeting of the Standing Committee of Justice and Human Rights to order as we commence our study based on the order of reference of Wednesday, March 8, 2017 on Bill S-217, an act to amend the Criminal Code Detention and Custody, or otherwise known as Wynn's Law. It gives me great pleasure to welcome our House sponsor of the bill, Mr. Michael Cooper, who is a member of our committee. What a pride it is of us to have you. So, Mr. Cooper, the floor is yours.
Great. Well, thank you, Mr. Chair, and thank you, colleagues. It's a privilege to be before you to testify on Bill S-217, known as Wynn's Law, named in honor of Constable David Wynn. Bill S-217 is a straightforward bill. It seeks minor amendments to the criminal code, minor amendments, however, that had they been enacted at the time that Constable Wynn was shot and killed, could have saved Constable Wynn's life. Before I go into the details on Bill S-217, let me at the outset provide some background in terms of what led to Bill S-217, Wynn's Law. During the early morning hours of January 17, 2015, Constable David Wynn and Auxiliary Constable Derek Bond were inspecting license plates outside of a casino in St. Albert, my home community. They were inspecting license plates as part of their routine policing. And in the course of inspecting license plates, they came across a license plate in the name of one Sean Rain, for whom there was an arrest warrant for. Consequently, Constable Wynn and Auxiliary Constable Bond proceeded into the casino to arrest Mr. Rain. Upon approaching Sean Rain, Rain began to shoot and shot Constable Wynn and shot Auxiliary Constable Bond. Tragically, Constable David Wynn died 4 days later on January 21st, 2015. Constable Bond survived, but I can tell you, having spoken with him, that his life will never be the same. Indeed, his life is in many ways a living hell as he seeks to deal with the impacts of being shot at close range, both from a physical and psychological standpoint. Constable Wynn's killer, Rain, was out on bail at the time. He was out on bail notwithstanding the fact that he had some over 60 prior criminal convictions, 29 outstanding charges. I said 38 before, but it was 29, and multiple failures to appear. It prompted RCMP Commissioner Paulson to ask how it was that such an individual was walking amongst us. And it turns out that the reason such an individual was walking amongst us was because this individual's criminal history was not presented at the bail hearing. One of the reasons why this information was not presented at the bail hearing is as a result of a loophole, and that loophole is in the criminal code found at section 518 sub 1 sub c. And that loophole, a fatal loophole, provides that the criminal history of a bail applicant may be presented, notwithstanding that the criminal history of a bail applicant is always relevant and material for a proper determination on the question of bail. The essence, the cornerstone, the underlying purpose of Bill S-217 is to amend Section 518, sub 1, sub C, to replace may with shall, so that in all circumstances the criminal history of a bail applicant is presented at a bail application hearing. The purpose of Wynn's law is to ensure that all relevant and material information is presented, something that didn't happen in the bail hearing of Shawn Raine with lethal consequences. Now, what Wynn's law would do is ensure that relevant and material information is presented, but what it would not do is in any way interfere with the discretion of a judge or magistrate to make a determination on the question of bail. Indeed, what Bill S-217 would do is give and ensure that the judge or magistrate had all of the relevant information before them so that they could properly exercise their discretion in determining whether someone should be kept behind bars or let out into the community. Moreover, Wynn's law would not impose any undue burden on the Crown, on prosecutors. Indeed, this type of evidence is almost always presented at a bail application hearing. What Bill S-217 would do is formalize in law what is almost always done and what should always be done at a bail hearing, so that what happened to Constable Wynn and Auxiliary Constable Bond never happens again. Now, in addition to amending Section 518 sub 1 sub C of the Criminal Code, there is also a secondary ancillary component to Bill S-217, and that is to amend Section 515 sub 10 sub C. Section 515 sub 10 is the section in the Criminal Code that sets out the grounds in which bail may be denied. There are three grounds set out in Section 515 sub 10. The first is at Section 515 sub 1 sub A, which is in the case of an individual being a flight risk. The second is at Section 515 sub 10 sub B, which is where public safety is at play. And then the third ground, and this is the ground that this bill would amend as well, is Section 515 sub 10 sub C, which deals with denying bail where confidence in the administration of justice would be compromised. There are four sub-grounds that must be considered under that question of the administration of justice being compromised. What this bill would do is make a minor amendment by adding three grounds in addition to the four that are already there, namely past convictions, outstanding charges, and failures to appear. But again, the overriding purpose, the overriding objective is the change to Section 518 sub 1 sub C, which is to change may to shall, so that the criminal history of a bail applicant is always presented at a bail application hearing. In closing, Mr. Chair and colleagues, what happened to Constable Wynn and Auxiliary Constable Bond should never have happened, and unfortunately we cannot turn back the clock. But as parliamentarians, we have an obligation, I believe, to close a fatal loophole so that this never happens again. We owe it to Constable Bond, to Constable Wynn. We owe it to Canadians, Mr. Chair. Thank you.
Thank you very much for your very compelling testimony, Mr. Cooper. And we're going to go into our first round of questions. We will start with Mr. Nicholson.
Well, thank you very much, and congratulations to you, Mr. Cooper, for sponsoring this bill. I think this is a very important bill in as much as that it closes a gap that exists within our criminal justice system. There are those who have commented on this that you, I'm sure, have read some of the comments with respect to this bill. One of them says that maybe we shouldn't support this because it would cause delays in the system, and all of us want to make sure that our criminal justice system at every stage acts in an expedited way. What is your response to those who are afraid that this may cause delays in seeing justice done?
Thank you, Mr. Nicholson, for that question, and indeed that has been one of the criticisms of the bill, was that somehow this would cause delay. And I say in response to that, with the greatest of respect to those who make that argument, that it simply doesn't hold water. And that is because this information is almost always presented. It's almost always presented because it's always relevant and material. So if something is almost always presented, how could it reasonably suddenly cause endless delay? It's just not so, Mr. Nicholson and Mr. Chair, and so I reject.
Say, Mr. Cooper, as well, that the times have changed. I remember starting to practice law myself. There were no computerizations or no available. They used to literally had to dig out the records of these guys here out of exactly out of the files, and sometimes it was very difficult to get the information on people. Wouldn't you agree with this day and age with computers that this should be very easily accessible in a very timely manner?
Yes, and indeed, literally this information is keystrokes away. This information can be pulled from CPIC. It takes literally a matter of minutes. If it's not available by computer, then it's certainly available by virtue of a phone call away from someone who can log on and access the system. So it is true that a long time ago, decades ago, and sometimes getting this information would just not have been possible, but that's not so today in 2017.
Let me ask you this. You mentioned in your opening comments that you heard some criticism with respect to this. Have you heard from others that are supportive or other groups that are interested in this bill that you have before us?
Yeah. We have received, there has been very strong support for this bill. This bill has been supported by a number of law enforcement members and law enforcement organizations, including the Canadian Association of Police. It has received the support of victims' rights groups. It has received the support of the former Minister of Justice in the province of Alberta, who oversaw the provincial response following the murder of Constable Wynne. It received the unanimous support of Liberal and Conservative senators when it passed the Senate, and in second reading, it received overwhelming support, including the support of unanimous support of the Conservative Party, the New Democratic Party, the Bloc Québécois, the Green Party, and 27 Liberal MPs. I would say this is not a partisan issue. This is something that people right across the spectrum can agree upon because it's the right thing to do, it's the common sense thing to do, it's the needed thing to do.
Hear, hear. Thank you very much.
Thank you very much. We're going to go to Mr. Fraser.
Thank you very much, Mr. Chair. Mr. Cooper, thank you very much for being here today and for your work on bringing this forward on the House side and getting it to committee. I can tell you that the passion with which you speak of Constable Wynne and his loss and that of Constable Bond is something that's not lost on this committee and not lost on me personally, and I want to thank you for bringing it forward. I think it's important for us to bear in mind, of course, what the bail provisions are all about, and that is to ensure that public safety is kept front of mind when determining judicial interim release, and also having an orderly justice system. At the foundation of that, of course, though, is that individuals who are accused of criminal offenses are presumed innocent until proven guilty, and therefore the obligation is normally on the Crown in order to prove that the person should be detained. And so it's important to bear that in mind when reviewing these provisions. I'd like to start first with a provision, the Section 515, which you, I guess, say is kind of ancillary, I guess, to the main purpose of this, which is changing the wording from may to shall in 518. In 515, 10A, so that's the first ground, I guess, that a person could be detained if they are a flight risk or if they're not going to appear in court. In 515, 10B is the ground that the Crown can rely on to show the person should be detained because they are a risk to the public, or they may reoffend, or they may interfere with the administration of justice. Then the third ground, or sometimes referred to as the tertiary ground, 515, 10C, is what it is that this bill is seeking to expand. And the grounds that are being expanded upon in the proposed bill here would overlap, I would consider, considerably with what has already been determined in 515.10a, flight risk, or 515.10b, public safety, by adding elements that were already considered in those first two, like the person's criminal record or the person's failures to appear. So in my view, I guess the Crown has already kind of had a kick at the can, if you will, on 515.10a to detain the person as flight risk, or in 515.10b because of their criminal record or because of their likelihood of reoffending. And I'm wondering why, then, you would see that an expansion is necessary when these things were already considered in the earlier provisions in this triage of elements to determine bail.
Right. Well, it's a fair question, Mr. Fraser, and thank you for that. I would say for a few reasons. I mean, first of all, the third ground, it had been characterized as a tertiary ground or a residual ground. In the Supreme Court St. Cloud decision at paragraph 34, the court clarified that it's not a residual ground, but one that is separate and distinct. And so the court said it's not one that, is a last resort per se, as it had been interpreted oftentimes in some lower court decisions in terms of its application. The Supreme Court in the St. Cloud decision made clear, as did the Supreme Court in the Hall decision, that the four factors that are expressly enumerated in the criminal code are the factors that must be considered. They're the primary factors that are to be considered on the question of confidence in the administration of justice, but that they are not the only factors. And in that regard, at paragraph 71 of the St. Cloud decision, the Supreme Court said that among the factors that should be considered, or often should be considered, include a criminal record. And so in that regard, what this would do is, in some respects, codify what the Supreme Court has already said is relevant and material on the question of that third ground, public confidence in the administration of justice. I would also add that the Supreme Court in St. Cloud and other decisions noted that the purpose of that ground is, of course, when public confidence in the administration of justice would be compromised, as it is stated on its face. And I would submit that there would not be an instance where public confidence in the administration of justice could be more badly compromised than seeing someone let out on bail when they have an extensive criminal record, outstanding charges, failures to appear, exactly the record of someone like Rain. So I would submit that in terms of that secondary ancillary component of Bill S-217, that it is consistent with the pronouncement of the Supreme Court in St. Cloud and also consistent with the purpose of that ground as enunciated by the Supreme Court.
Okay, thank you for that. In section 518(1)(c), in that proposed section, you're suggesting that that the third ground in the bill here is to prove, you say, to prove the fact that the accused has previously committed an offense under section 145, which is already there in the language, but then you're adding the fifth one, small Roman numeral 5, to prove the fact that the accused has failed to appear in court on one or more occasions when required to do so. It would seem to me that there's significant overlap between these two provisions, since section 145 is about failure to appear in court or when required to do so. I'm wondering if you have some comment on what small Roman numeral 5 may be referring to, and I'm wondering if it has anything to do with some evidence that the Crown could adduce that a person has failed to appear in court when subject to a subpoena as a witness, or is this something else?
Well, no, it certainly wasn't intended for that purpose. It is simply to clarify, again, that would be one of the grounds, failure to appear.
But you think, though, that since it's already covered by section 145, I guess, which is a person convicted of a failure to appear or not having appeared when requested to do so by the court, why is small Roman numeral 5 necessary?
Sir, and you're saying it's duplicated from where?
Okay, so
if you look at subsection 3 is what Mr. Fraser's referring to.
Right. Yeah.
So there's two things that seem to do the same thing. Reference to proving the fact that an accused has previously committed an offense under section 145 is already in there, and you're seeking to add the fact that the accused has failed to appear in court, which is already covered by 145. I'm just wondering why you're adding it if it's already covered.
I think it was simply to clarify that. So if there's redundancy, there may be.
Okay. I want to...
You're sort of exceeding your time right now. Is it okay if I come back to you in the second round and we go to Mr. McGregor now?
Yep.
Thank you. Mr. McGregor?
Thank you, Mr. Chair. Mr. Cooper, thanks so much for appearing today and for taking the time to sponsor this bill. The very fact that you chose to sponsor the bill, you've obviously had some very deep and thoughtful conversations with Senator Runciman over the scope of this bill. And I'm just wondering, my first question is just regarding in section 518 sub 1 sub c, you inserted the phrase "the fact" in there. And I'm just wondering why that was. What purpose do you see that particularly serving?
Well, that additional wording was wording that was recommended by the drafters, and it was incorporated into the bill for the purpose of expressly acknowledging that evidence only need to be led to prove the facts stated in the sub-paragraph. So that was the reasoning. It was on the recommendation of the drafters for that additional wording.
Okay. And you're changing the wording, for the prosecutor leading with evidence to go from may to shall, leaving aside both of those words and what their implications are for the particular section. What is your understanding of how the current CPIC system operates in Canada, based on, you helping shepherd this bill so far? Because you've obviously been you've listened to some testimony from the Senate side, and what's your understanding of how CPIC currently operates in Canada?
Could you be more specific?
Does it function well? Are there delays, gaps, and so on?
Yeah.
What's your understanding of it? Yeah.
Well, the CPIC system operates well in the sense that a police officer can go on to CPIC, and can obtain information on the criminal history of someone in a very short period of time. And I would note that during the evidence before the Senate Legal and Constitutional Affairs Committee, that John Muse, who has some 30-plus years on the Toronto police force, gave evidence that this information was keystrokes away, at most a phone call away, information that could be obtained in a matter of minutes. And I would also note that during the House of Commons debate, Glenn Motz, the Member of Parliament for Medicine Hat, Cardston, Warner, who has some 35 years of recent policing experience, gave evidence again that it had been his experience that between CPIC as well as local and provincial databases that information can be accessed and accessed quickly.
Okay. I wanted to follow up on what Mr. Nicholson asked you about. Some people have brought up the question of delays, and now we had testimony at the Senate committee by David Truex, the Ontario superintendent, and if I can just read a quote, he said that if these amendments contemplate the Crown leading evidence and providing facts akin to a trial as opposed to obtaining relevant documentation from the police and presenting it to the court, for example, by reading in this information, it is conceivable that this evidentiary requirement may significantly lengthen bail hearings with further added pressure on police resources and create further adjournments that could prove to be counterproductive in a system that is already strained and operating at full capacity. Now, you and I, of course, have taken the Liberal government to account because we know very well what the delays in our justice system are. In fact, recent media reports have shown that very serious criminal charges are being stayed or withdrawn. So I'm just wondering if you can just respond to that testimony in light of how overburdened you and I know our justice system currently is.
Well, I would state that it's just not so, that this bill would create any real delay because, again, this sort of evidence is almost always presented in court. It formalizes, in essence, what is almost always done. And I would note further that this bill does not in any way change the rules related to evidence at a bail application hearing. Those are set out, for example, in Section 518 sub 1 sub A, which says, among other things, that the justice may make such inquiries on oath or otherwise concerning an accused as he considers desirable.
What's my time at?
You have another 35 seconds.
Okay, so just one quick question. So we know that our poor people and marginalized people, people such of color and mentally ill, are more likely to come into conflict with the law. That's just a statistic that is very much known. Do you think that Bill S-217 might, have some changes on the makeup of the remand population in provincial correctional facilities across the country? And do you think that, specific minorities might fall in the trap of being disproportionately affected by this particular legislation?
Yeah. Thank you, Mr. McGregor. It's a good question, and the answer to that is no. No, because what this bill doesn't do is change the rules around bail. It doesn't interfere with the discretion of a judge or magistrate. All it does is ensure that information that should be presented is presented, and it's up to the justice or magistrate applying well-applied law to make a determination as to whether or not someone should be let out or not.
Okay, thank you.
Thank you very much, Mr. Biddle.
Thank you so much. Thank you again, Mr. Cooper. I'd like to echo what my colleagues have said in terms of bringing this forward. This is clearly a tragic occurrence, and I do appreciate your efforts. But I'd like to dig down a little bit on some of the legal points within the bill. I'd like to build upon what Mr. McGregor talked about in terms of the term fact. that's used, the fact. It doesn't appear anywhere else in the criminal code. I know you discussed the drafters suggested that, but is there any further information you can provide to us and whether this would lead to any legal complexities and court challenges if a term is used in this particular section that isn't found elsewhere in the code?
Well, thanks, Mr. Biddle. First of all, the only reason that language was incorporated into the bill was based upon the recommendation of the drafters for expressly acknowledging that evidence only need to be led to prove the facts stated in those 4 and now it would be 6 subsections. So that was the purpose of that. The intent was not, for example, to change the evidentiary burden that must be made out at a bail hearing, and to the degree that it is somehow found that that wording does that, somehow do that. That was not the advice that we had received, but if that was the conclusion, then it should be removed because that's not the intention.
And I agree with you. You mentioned that a lot of what you're bringing forward in terms of changes to the criminal code almost always happens, especially in terms of presenting a accused criminal record. I've talked to prosecutors, defense counsel, legal aid organizations. I've had a lot of conversations about it. But what about issues like consent matters? Is the intention of the bill to still go through that process when the Crown and the accused have come to an agreement, keeping in mind all of these things? And might that, may not build in a lot of delay, but it still might build in some delay into the court system itself?
Mr. Biddle, of course it is ultimately the judge or magistrate that makes the determination as to whether or not someone is let out on bail, and that includes in consent matters.
And what about even the terms of prosecutorial discretion? And I know, again, you are correct. In almost all cases, this is happening anyways. But are we going down a slippery slope in terms of what Parliament is saying for prosecutors to do and infringing on their discretion, which is a constitutional principle in and of itself, and what the Supreme Court in the Krieger case referred to as a term of art? Are we, is it a potential slippery slope if Parliament's telling prosecutors how to do their job?
Right. Well, Mr. Biddle, I would submit that the duty of a prosecutor in the context of a bail hearing is clear, and that is to present the best and most attainable evidence about the criminal history of an accused seeking bail, and that's precisely what Bill S-217 does.
In terms of, and I know the intention is public safety, and I think, I know we have a tragic mistake by a police officer who was conducting the original bail hearing in the first place that led to tragic consequences beyond. This bill doesn't provide for any punishment, not that I'm suggesting it should, but are we exaggerating the public safety message on this particular case? Because these types of things still can slip through the cracks. I know it's your intention to really crack down on that, but are we overstating the public safety value of this bill?
Well, Mr. Biddle, I would just submit that the purpose of this bill is simply to do what should always be done, which is to ensure that this type of information is presented. It removes any ambiguity that exists by changing may to shall.
Okay. Thank you.
Thank you. So what I suggest we do is now go to shorter questions so everybody can ask whatever questions they have. So who has some questions? Mr. Fraser, yeah, you didn't get to wrap up your last comments, so please go ahead.
All right, thanks very much. Mr. Cooper, I'm just, with regard to the 518(1)(c) provisions that you're seeking to change, it's now going to, if your bill passes, going to be required to submit evidence of the accused's criminal convictions for determination. What's your view on how that would be interpreted as far as pardons or absolute discharges that have been granted? Do you have a comment on that? Because I would imagine that it wouldn't include that type of information to have to be presented to the court.
Yeah, that's correct, Mr. Fraser, in terms of pardons and conditional and absolute discharges. That sort of evidence would not be presented. In fact, in terms of pardons, such information in terms of prior convictions that are pardoned or removed pursuant to Section 2.3 sub B of the Criminal Records Act. Discharges are similarly removed pursuant to Section 6.1 of the Criminal Records Act. So no, that type of information would not be presented in the case of pardons and conditional and absolute discharges.
Thank you. I have a couple other quick ones, but I don't know if Mr. Falk had a question. Do you want me to finish?
Why don't you do your couple, and then we'll go to Mr. Falk.
I'll be brief. Since the requirement will now be on the Crown to lead this evidence if this bill is passed, rather than suggestive that they can do it, this might be a strange question, but I'm just wondering, when they're proving a fact or submitting the evidence, that the accused has previously been convicted of a criminal offense. It would never have come up since it was made, but now that it's a requirement to do so, does it make sense to specify that it be a criminal offense committed in Canada, or is this any criminal offense having been committed that the Crown is now required to adduce evidence on?
Well, it would be based upon criminal evidence, any evidence that is attainable and available to be presented. So, it's.
What would be, okay, so what would happen though if evidence of a criminal conviction in the United States, for example, was not presented because it at the time wasn't obtainable? Then what would happen to the decision made by the court at that bail hearing? Could it be vitiated by a further proceeding?
Well, the intent of the bill is to maintain the type of evidence that is almost always presented, and to codify that by making it a requirement. So that is the purpose of the bill, is to ensure that the types of evidence that is typically presented, almost always presented in court, that is readily and easily attainable, respecting the criminal history of an accused, be presented.
But I guess, do you see that including trying to find if there's any international information that could be relevant to that person's record?
Well, I mean, obviously, if that information was readily attainable and available, then it should be presented. But in most cases, I presume it wouldn't be readily attainable.
Do you think there'd be any use in adding the words of a criminal offense in Canada?
Certainly, perhaps that's something that the committee could look at.
Thank you.
Thank you. Mr. Falk.
Thank you, Mr. Chairman, and thank you, Mr. Cooper, for presenting to committee. Not often do we get the opportunity to have you at the other end of the table. I think it's probably a delight for most people. You know, back in my home province of Manitoba, I was speaking with the Manitoba Safety Accident Investigator, and he, in the course of an investigation of an accident, and we were talking about it, and I said, so what kind of things are you looking for? And he said, well, I'm looking for if the individual was trained properly, if there was a proper work procedure for what was supposed to happen, whether the employee followed the procedure, and whether something was gone. And he says, at the end of the day, he says, what we're looking for is links in the chain that are missing. And you know, when I look at subsection C of 518 subsection 1, you've changed the wording from may to shall. And it seems to me, when I look at the situation with Constable Wynne and Auxiliary Constable Bond, that the tools were accessible and readily available to them, but it wasn't necessarily prescribed that they use them. and as far as a police officer conducting the bail hearing, and he obviously didn't use all of the resources that were available to him. It seems to me that the intent of this bill is to make sure that the link in the chain that was missing is now put back in to make the chain complete. Would that be your understanding?
Yeah, well, that's a fair point, Mr. Falk. It's about ensuring that information that is available, that is accessible, that is attainable, is in fact presented as it should be.
Are you also aware in your study of this bill and in support of it, were there any other situations similar to this where had the information been provided at a bail or bond hearing where it may have made a difference to someone, either a law enforcement officer or an individual in the public?
Well, I guess we will never quite know how many cases there are where this information isn't presented. We certainly know about this case, and it resulted in the most serious of consequences possible, including the loss of the life of a brave police officer and a life of an auxiliary constable whose life has been turned upside down as a result.
Yes, I think you're right. It certainly would have made a difference in this one. Thanks, Mr. Chairman.
Thank you very much. Mr. McGregor, and then Mr. McGregor, and then Mr. Boissonnault.
Mr. Cooper, I just wanted to quickly revisit, the state of record keeping in Canada, because, I was going back over the transcripts from the Senate committee, and Senator Runciman actually in his Q&A session with members of the committee did note that, they've been talking about how trying to get the Ontario system away from a paper-driven system for many years. He mentioned, we're going back 15 or 16 years, and there's been very little progress and millions of dollars spent. So, leaving aside the intent of this bill, I'm just wondering, if we have what amounts to a patchwork quilt across Canada and we don't have that up-to-date record system, do you think maybe it would be better for the government to concentrate its resources in making sure that we have a nationwide up-to-date computer system where a magistrate has that information at his or her fingertips, so that so you're not really putting the onus on the prosecutor anymore because that information is available before the magistrate? I'm just wondering if that, in your opinion, might be a way that we could solve this problem and also make sure that a tragedy such as what happened to Constable Wynne doesn't befall on anyone else.
Right. Well, thank you, Mr. McGregor. I would submit there really are two separate issues. One is with CPIC, which is accessible right across Canada, but I understand there are some issues in terms of how quickly
entering the data,
the data is entered, and some backlogs and delays. And that's just frankly unacceptable. It's absolutely unacceptable that CPIC isn't fully up to date in all cases. But the fact that there may be some backlog in CPIC does not change the fact or impact upon the fact that the criminal history of someone should be presented at a bail application hearing. After all, such information, as I've mentioned, is always relevant and material. Indeed, oftentimes it is about the only evidence that is relevant and material at a bail application hearing. So what I would submit is that we should amend the criminal code to close this loophole and to continue to put pressure, as there has been pressure put, to get CPIC fully up to date.
But I guess what I'm saying is it may not even be a loophole if we were to tackle the quality of the information readily available. Maybe that's just one way of looking at it. Perhaps.
Well, it is a loophole if the information isn't presented. I mean, you could have a perfect CPIC system and not have the information presented. In this particular case, the status of CPIC would not have changed the fact that the information wasn't presented, information that was readily available, information that was on CPEC, and information that, had it been presented to a judge or magistrate, almost certainly would have kept Sean Rain behind bars and Constable Wynne alive today.
Okay, thank you.
Merci beaucoup, Monsieur Boissonneau.
Thank you, Mr. Chair. Mr. Cooper, thank you very much for your work on this important consideration of our criminal code, and I appreciate you taking the time today to speak with us about 217. I have some questions and some concerns about the proposed legislation, and I'm hoping that you can shed some light on those concerns. And I think it's important to note that there isn't a single parliamentarian that doesn't acknowledge the tragic circumstances that led to the thinking that is behind the loops that are attempting to be closed by S 2017 or by S 217. My concern is threefold. So 3 questions. One is related to the delays in the system that will be invariably introduced in the system should this legislation become the law of the land, including in non-contested hearings. If this passes, it would have to be considered in a non-contested hearing, and if that only added 5 minutes, if we're doing 30, 40, 50 bail hearings a day, the system of justice will slow down. And you are on the record as well, sir, having said that we need to do better to speed up the wheels of justice. Our government has done its part, in part, to have 12 judges nominated in Alberta. And so I see a dichotomy here between, on the one hand, wanting to speed up the wheels of justice, and yet on the other, introducing potentially serious consequences at bail hearings should S 217 pass. That's one concern. The other concern is I think this tries to legislate human error. And as much as I think there's legislation we'd like to see in the criminal code that could legislate human error, I'm not sure how that's possible and how we could have that come out of the system. And then thirdly, the Alberta Bail Review, conducted by former federal prosecutor Nancy Irving, raises serious concerns and strong objections to the practice of some 3,000 police officers being able to represent the Crown at bail hearings at all. And I know that's under consideration in Alberta right now. And my question to you is, if we had Crown prosecutors at bail hearings instead of police officers who are better trained and understand the nuances of this, wouldn't that obviate the need for S 217? And finally, I think it's important to note for the record that it was the Conservative government in 2015 in their budget that cut CPIC by 10%. And I also think it's important to note that the last AG's report noted very clearly that the delay in getting the information from conviction into CPIC is 14 months in English Canada and 36 months in French Canada. And I see this as a compounding of that already, and that's why I have grave concerns.
Well, Mr. Boissonneau, first and foremost, it is again the judge and magistrate that makes the determination as to whether or not someone should be let out on bail, and consequently, the information about the criminal history of an accused seeking bail remains relevant and material even in the context of a consent application. Secondly, with respect to the Alberta Bail Review, I would note that the Alberta Bail Review takes for granted that this type of information should always be presented at bail application hearings. I would draw your attention to page 3 of that report, wherein the author states that there was virtually unanimous agreement from all of those consulted on 4 issues, including all participants in the bail application process, which would include a judge or magistrate having access to complete and accurate information, and that convenience and efficiency should not be allowed to trump the integrity of the process. And I would also draw your attention to recommendation 25 of the report arising from the Alberta Bail Review, wherein it was stated that before a bail hearing, the police should provide the Crown Counsel with the following information: at a minimum, an up-to-date criminal record, including both a CPIC printout and a join sheet, Alberta, and information on outstanding charges and copies of forms of release on those charges. And with respect to police officers conducting bail hearings, that has been done in the province of Alberta. It has also been done in British Columbia and province of Saskatchewan. We have, as a result of a reference that was put before the Alberta Court of Queen's Bench, a decision of Chief Justice Whitman that made certain findings in terms of the jurisdiction of police officers to conduct bail hearings in the province of Alberta.
I appreciate that. I just think it's really important to note in this discussion that it's a practice that across the country is strongly opposed by those in the justice system, and that I know it would cost more money if we had Crown prosecutors instead of police officers doing it. Could be a more just approach to follow Crown Prosecutor Irving's recommendations. But I'd like you to address my particular question around this slowing down the wheels of justice. And actually, there's just only so many hours in the day, Mr. Cooper, and I do not yet understand how passing S17 is going to actually make the justice system faster, more efficient in the course of meting out justice.
Well, I reiterate that I don't see how this is going to slow down the process to any degree, and to the degree that it does slow down the process so that someone like Sean Rain isn't out on bail and on the street, so much the better.
Yep, Mr. Nicholson.
On Mr. Bossino's comments. He said that, with the enactment of this bill, we could be adding an extra 5 minutes to every, bail hearing. And, I guess in Toronto, they might have 30 or every morning or something. But that being said, in your examination of this is information that they present all the time anyway, that it's an exception to the rule, isn't it? So I guess what we're talking about, that 5 minutes would be the exception to the rule when the Crown or the police or whoever is conducting the bail hearing doesn't give this thing there. And I think you've made that clear, that it's very seldom that they don't present this information. So I'm completely at a loss to say how every bail hearing now could be extended by 5 minutes here, because they're reading in information that generally is before them in every case, in any case.
It just doesn't make sense, Mr. Nicholson. It's not supported by the evidence before Senate Legal and Constitutional Affairs Committee. It's not consistent with the representations that have been made by the law enforcement community, which has overwhelmingly supported this bill. And I would also say that when we talk about 5 minutes, I say that Constable Wynn's life was worth 5 minutes. His life, in fact, was worth a lot more than 5 minutes. 5 minutes that could have been done to check the T, cross the T's, dot the I's, and make sure that someone like Sean Rain was not let out.
Sure, thank
you. I have a couple of questions. Mr. McKinnon, I'll go last. Mr. McKinnon?
Yeah. So it seems the thrust of this bill is about public safety, although it states in our notes it's about maintaining confidence in the administration of justice. But your remarks are all about safety, fundamentally. Yet we don't know that had this information been presented in the case of this individual, that he would not have been given bail in any case. So it's pretty hard for. I mean, hindsight is 2020, but it's hard to say that had this information been presented, that he would not have been given bail anyway. So I guess I'm kind of struggling with the notion that this really does advance public safety. Some of these provisions, for example, looking at the individual's propensity for not showing up in court, those certainly speak to his likelihood to come back in this case as well, but that doesn't necessarily speak to him as a public safety risk. Similarly, the fact that he might have had previous criminal convictions or a criminal record, I think you'd need to speak to the nature of those criminal offenses to decide whether or not he was a public safety risk in those cases. So while I accept that this will encourage a tighter view of an individual to whether or not he will in fact show up when he's supposed to, I'm not seeing that this necessarily speaks to public safety.
Well, thank you, Mr. McKinnon. I would say, Mr. McKinnon, in response, that in terms of what happened to Constable Wynn and what happened at that bail hearing, I guess we'll never fully know. But what we do know is it wasn't presented, and we know that there is this loophole in the criminal code, and that's what this bill seeks to close. Because again, this information is always relevant. In fact, when we look at the 3 grounds that are set out in the criminal code at section 515 sub 10 in terms of grounds or justification for detention, that criminal history is relevant in all three cases. So I think it certainly goes to public safety in terms of ensuring that a judge or magistrate has information to know whether the person has an extensive criminal history, to know whether they're a flight risk, and to know whether they have an arm's length of outstanding charges. Of course, it's still up to the judge or the justice of the peace to make the final call as to whether or not that person is suitable for bail, and if so, what the condition should be, if any.
One quick one?
Yes, of course.
I guess carrying on here, so the distinction between shall and may in this amendment, so we changed the word to shall, so these things shall be presented, but as Mr. Boissonneau pointed out, we tend to be, it looks like we're trying to legislate against human error. These data, as you yourself have testified, are almost always presented. So what is the significance of putting shall here when it doesn't stop someone from making a mistake and failing to follow through on this? So if someone fails to follow through on this, and it says these shall be considered, but they release the person anyway, what is the consequence of that?
Well, it removes any ambiguity. It removes any ambiguity. That's what it does. There's absolutely no basis for it to be made, because this information needs to be presented in order for a bail application hearing to be properly conducted. So why would we leave a word that is ambiguous, such as may, and not change it to shall, to close the loophole, to make it clear?
So I recognize that as a legal distinction, but in practice, if someone fails to do this and the individual is released, what then happens? The fact that we've changed it from shall or may to shall really would have no effect in the case of human error once again, right?
Well, in the case of human error, I mean, there could be human error. You can never prevent everything. Human error, I agree, you can't legislate against human error, but what you can do is minimize the likelihood of something like this from happening, and one way to minimize it is to remove the ambiguity by closing the loophole.
Thank you. Thank you very much. Mr. Fraser?
Thank you. Just one of the things I thought of when listening to the other questions and answers on the delay aspect. I take what you say on with regard to the criminal records being presented, and that should happen as a normal course. But with regard to one of the grounds that you're adding, and that is to show circumstances of the alleged offense, particularly as they relate to the probability of conviction of the accused. So that evidence would now need to be presented to the court. It's not a suggested thing. And I guess I'm wondering, I would see this ground as being the one that would perhaps cause more delay, because the extent of the evidence, or the extent to which that evidence needs to be adduced, could be different case by case. And in some circumstances, it could require extensive evidence to satisfy the court whether or not there were circumstances of the alleged offense that, or the probability of conviction of the accused would happen. So if a police officer weren't available, perhaps the bail hearing would have to be set over. And so it's this ground that I would see would be problematic with regard to delay, more so than the criminal record being adduced or failures to appear. I'm wondering if you could comment on that.
Yeah. Well, it's a fair point. I don't see it in most circumstances causing delay, of course, depending on the particular circumstances surrounding the individual application. There are always times when when bail applications are put over, but I don't think that in the normal course of things that it would significantly or in any real substantive way impact upon how long a bail application would take to be heard and determined. Okay, but it's always possible that in some cases, you're going to have certain facts or certain circumstances in which there may need to be an adjournment. That's the case as it presently is in the case of bail hearings.
Okay, but with regard to the extent of the evidence, I guess, like right now, it could be determined quite quickly that this case wouldn't, we don't really need to get into the details of the circumstance of the offense because it's not as grave an offense, but this requires it for all bail applications regardless of the offense. So it could, in those more simple cases, I guess, add the time it would take to determine that bail hearing on something that normally you wouldn't be considering the circumstance of the offense because that third ground for bail detention wouldn't normally be, I guess, the ground that the person would be held on. But they're required to produce that evidence anyway.
Yeah, Mr. Fraser, I take your point. I just don't see that in the normal course that it would cause a substantive amount of delay or a whole new layer to the process. But I take your point.
All right, thanks.
Thanks very much. Anyone else? If not, I just have a couple of small questions. First of all, I wanted to thank you for presenting not only the bill, but also for the passion in which you've advanced the cause of your own constituents, the family of Constable Wynne and Constable Bond. And I think we all appreciate both you and Senator Runciman's work on that. I see the bill really in two layers. I mean, I really see the change to Section 518 and the may to shall as being one layer of the bill, which I think you yourself, Mr. Cooper, have suggested is the most important layer of the bill. It's not the question of trying to remove the fact that there's going to be errors. It's taking away the right of the prosecutor, the discretion of the prosecutor to just fail to present it purposefully. So it's not to solve the question of not having errors. We all know there may be errors. If somebody says shall and he doesn't do it or she doesn't do it, there still may be an error in not presenting it, but it takes away their purposeful failure to present it. And so I see that as being the difference. But can I ask the question, because I think it's sort of been bandied about a couple of times, what would essentially happen in the event that we say shall and the prosecutor fails inadvertently to do this? What would happen to the result of that bail hearing? Could the bail hearing have to be reconsidered? What do you think would actually happen?
In that particular circumstance, well, it's possible that it might have to be reconsidered if information wasn't available. But in terms of what would happen to a prosecutor, obviously there is no penal consequence. There's no punishment set out in the criminal code, of course. If a prosecutor doesn't do what is required of him or her, then obviously there are certainly consequences for that prosecutor, but not criminal code consequences.
No. Right, understood. I was more concerned about what would happen to the person who perhaps would be let out on bail, and then would this be revisited if somebody said, hey, you didn't present this? And I mean, would we have people showing up in the system multiple times because of errors? Or do you just see that there's going to be an error, it goes ahead, the decision rests, and...
Well, yeah, I mean, I would think that in the normal course, I mean, if a decision is made based upon the attainable and evidence before the judge or magistrate, I think that would be the normal circumstance. The decision is made based upon the information.
Fair enough. And so my second question, and this relates to 515-10C, and again, I come at it that there's two different layers to it. One is changing may to shall, and one are the other additions to the bill. Some of which I think I view as unnecessary, but in terms of looking at the proposed change to subsection C, subsection 6, I understand that the court has said that the criminal record of the accused is one of the areas already under subsection C that they would see as being a general thing you would look at. But the criminal record would not include whether somebody has been charged with another criminal offense and never been found guilty. And so while I understand the purpose of saying somebody didn't show up in court, somebody has been found guilty, why would we be introducing the fact that somebody has simply been charged with another offense when we're presuming they're innocent until proven guilty?
And just to clarify, I was just trying to find the section. So you're referring to
515-10C, subsection 6, the proposed new language?
515-10?
Yes, 515-10, subsection C, subsection 6.
Yeah.
where it says, or has been charged with and is awaiting trial for another criminal offense?
Right. Well, I mean, that, again, is information that would be in the mix already. And in fact, as is noted in the Alberta Bail Report, that type of information was expressly noted as something that should always be presented and always available. So it's not determinative. I mean, the test when we look at 515 sub 10 sub C is to look at all of the factors that are expressly enumerated, other factors that may be applicable, and in the Hall decision and the St. Cloud decision, the Supreme Court has been clear that no one factor triumphs another, and it's not a matter of taking one and basing it on one. It's a matter of looking at all circumstances in the individual case.
So one last question, Mr. Cooper. When I look at 515.10b, which is the public safety element of 515.10, which talks about why the detention of an accused is justifiable, it talks about public safety issues. Would you agree that if the prosecutor does not introduce the evidence under 518.1c, then it is difficult for the magistrate to make a proper conclusion under 515.10b?
I would agree.
Okay.
I don't think you couldn't make it.
Yeah, I agree. Okay, any other questions from anyone? If not, may I ask, and first of all, thank you very, very much, Mr. Cooper, for your very cogent testimony. It's much appreciated. May I ask, could we stay behind and go in camera to talk about future witnesses under the bill and how many meetings we'd like to have? Perfect. So meeting for the moment suspended.